This is Senior Living Today with attorney Jeffrey J. Rokisky.
Welcome to this edition of Senior Living Today with estate law and nursing home planning attorney Jeffrey J. Rokisky. Hi, I'm your host, Kelly McCoy. We want to say thank you for the continued response to these shows. Not only have we been tackling your estate law and nursing home planning questions for the past couple of years now, but we're also delving into the very complex issue of oil and gas rights, which is exactly what we are doing here once again today. But before we get to all of that, let's talk a bit about attorney Jeffrey J. Rokisky. He was born and raised in the Ohio Valley and graduated from West Virginia University with a degree in accounting. He's also a graduate of the West Virginia University College of Law and holds a master's degree in tax and estate planning from the University of San Diego School of Law. Jeff is a member of the National Academy of Elder Law Attorneys and is a member of the West Virginia, Pennsylvania, and Ohio State Bars. He has offices in Weirton, Wheeling, Morgantown, Robinson Township, Pennsylvania, as well as Clarksburg and Elkins, West Virginia. Jeff's been named Best of the Best in Estate Law by readers of the Weirton Daily Times many times over the past several years. Now, once again, we're going to get to that very hot topic of Marcellus Shale gas rights. Jeff, this is what people are talking about. Many say this could change the face of the economy in the region and here in the Ohio Valley. So let's get right to our first question, which comes from Alan, who is from Jefferson County. He says about 3 years ago, he signed a lease with a gas company who told him they were going to drill a successful well on his property. Then they paid him $10 an acre and 12.5% royalty. Now, many of his neighbors, he says, have recently signed leases for not only much more money, but a higher royalty. The gas company he signed with sold the lease to another gas company. He wants to know, is there anything that he can do now to get out of this lease, Jeff?
We hope so, Kelly. It seems that everybody that we've talked to that has been fortunate enough to sign a good lease, a fair lease, there's been somebody who has essentially been taken by a gas company, or what we call a flipper, somebody who signed somebody up for a very low amount, no intentions of ever drilling on that property, fully understanding what the landowner had, even though the landowner didn't, and then taking advantage of that knowledge and assigning them to a very poor lease, and then assigning the lease to an actual company that will do the drilling, and making a lot of money on the difference between what the landowner agreed to sign with them and what they were able to assign to an actual gas company that will do drilling. There's two schools of thought there. First of all, if there were any misrepresentations that were made by that flipper or landman in inducing the landowner to sign the lease, the same contractual issues exist with fraud. In other words, they were induced by fraud to sign that lease, and they may be able to set aside that lease under those circumstances. So in other words, if they made misrepresentations, made false statements, it is possible that the lease can be set aside under those circumstances. The second theory is that just the fact that these landowners were grossly underpaid to begin with, that there was inadequate consideration. And the standard seems to be in that area that the amount that they were paid shocks the conscience. And certainly if we have somebody who's getting $10 an acre and 12.5% royalty, which is the bare minimum by state law, I mean, they have to be paid that amount. I think that there's a strong argument that they really weren't paid anything at all, and therefore there's not a binding contract, and therefore they may be able to take that contract to court and possibly set it aside. My firm, we come across this, like I said, almost on a daily basis. What we're doing is we're working with firms of litigators, very good litigators, who are going to look at these leases with us on a kind of a case-by-case basis, see if there was any misrepresentations that were made, compare the consideration that these people were receiving, what they actually probably should have been receiving, and possibly, file an action in court to set aside these leases. So it's certainly something that our firm's looking at in conjunction with other firms, and hopefully we'll have success, because again, it's, a lot of these people unfortunately were taken advantage just because of their lack of knowledge.
And it was new, probably,
It was
when
new.
they signed.
Right. There's a very good article in a law review article that came out of Texas recently, and they talked about in Texas the same thing happened with the Barnett Shale, where all this horizontal fracking started. The fact that these landmen came in early, in the development of these gas wells before anybody truly understood how valuable their rights were, and did the same thing. And only after a certain amount of knowledge was gained by the community did people start to sit back and say, wait a second, we understand that we're really entitled to a lot more than our fathers or grandfathers were for these shallow vertical wells. And eventually, down in Texas, just like in this community, people started to get the money that they truly were entitled to.
Okay, now on to our next question. Mary from New Martinsville says that she just added an oil and gas seminar. She just attended, rather, an oil and gas seminar where the speakers kept emphasizing the need to have a pew clause inserted into her lease. She says, I don't think half the audience really understood what the speaker meant by a pew clause. What is it? Could you please explain it?
Okay, well, I will tell you that it's a very complicated concept to understand, but yet it's very important that our audience does understand. Through no fault of the speaker that she attended the seminar with, it's a complicated subject. Basically, the way the pew clause works is, let's assume that you have 200 acres, and you sign a lease with a gas company, and they pay you $2,500 an acre up front and 15% royalty. You get your $2,500 an acre up front for that 200 acres when you sign the lease and after they've done a title search to make sure you own.
Nice piece of money there.
Yeah, very nice. I wish I had 200 acres.
So do I.
But anyways, you're going to get your money for your acreage up front, but you will not get the 15% royalty until they actually sink a well which utilizes a portion of your property. Okay, so again, the money, the $2,500 an acre, you get that up front, and then when the gas company sinks a well and your property is part of what we call the drilling unit, then and only then will you get paid your royalties. And let's say, for example, that they sink a well and they develop their drilling unit, which is generally about 640 acres to 1,000 acres, and only 20 acres of the 200 acres is being utilized as part of that unit. You are only going to get your royalties on the 20 acres that are being made productive. Okay? And so in other words, the other 190 acres that are falling outside the unit, you're not going to get paid that 15% production rate for. And at first blush, I think everybody says, well, that makes sense because, why should they pay me royalties on the 190 acres if they're not making them productive, if they're not taking gas out from underneath my land? And they're right. There's no reason you should get paid for that. The problem is this, that if another gas company comes along and says to that person, we would like to sign you up for a lease, we notice that your 190 acres aren't being used, aren't part of a drilling unit, we would like to sign you up with a lease with our company so that we can make your 190 acres productive. Mm-hmm. Without a pew clause, you are not able to sign a lease with that second company because you're already obligated the 200 acres to the first company. So what a pew clause does, it says to that first company, I'm going to give you my 200 acres to make productive, and if you don't make that acreage productive within, let's say, 5 years, which is very common, then any portion of my property that you haven't made productive, I'm free to go out and negotiate a lease with somebody else who might make that property productive. And so that's I know it's very complicated.
Actually, I think it's actually quite understanding how you just put, or understandable, I should say, how you just put it. But my question, Jeff, is that's something you always have to do in the offset, in the very beginning, correct?
Right. If it's not in the lease to begin with, then you can't negotiate it later on in most cases. And I will tell you, the standard lease that a gas company is going to give you from the beginning is not going to have that pew clause in there. That is something that you're going to have to be aware of and something that you're going to have to make sure that is negotiated into the lease.
Okay, let's go on to our next question. Now, Joanne from Chester says, Jeff, I signed a terrible lease 4 years ago. In February 2012, my 5-year lease will be up. Does that mean I will be free to renegotiate better terms for my lease, Jeff?
Maybe. It depends on what her lease says. If her lease has a renewal clause, and the renewal clause, the common renewal clause that you will find in the very first lease that the gas company is going to give you without any addendums, typically would say that they can renew the lease for another 5 years, and all they have to do is pay you the same consideration that they paid you for the first 5-year lease. So if she, for example, was only getting $10 an acre for the first 5 years, then the gas company can hold her to another 5 years simply by paying her another $10 an acre. Okay, so renewal clauses vary. Sometimes you're free after 5 years to go out and seek a better offer. And if you find a better offer, then the gas company can match your offer. It really varies lease by lease. But
never black and white, is it?
It's never black and white, which is always why you should have an attorney, somebody experienced in oil and gas law. Take a look at it and make sure that you understand your options. And again, I have to say, you need to probably have counsel before you sign the lease, because just like in Jill's instance, she's already signed the lease. So she's going to be bound by that renewal clause unless, for example, she consults with an attorney who deems that, like we talked about with the first question, maybe that lease is something that can be set aside by a court because she was paid grossly inadequate consideration. Other than that, you're stuck with the lease that you signed.
Okay, we're talking about, that was Joanne.
That's right.
From Chester.
Yeah.
Okay, our next question is from Jill from Weirton, who says that she's heard so much about joining a landowners group. She asks what the advantages are and the disadvantages of joining such groups. She also wants to know if she can join such a group even if she doesn't want a company to actually drill on her property.
Mm-hmm. Well, that's a very interesting question. Landowners groups, there's a lot of active landowner groups right now. We have a landowners group in Hancock County. We've had a landowners group in Belmont and Monroe County. There's been articles in the paper recently about other landowners groups. And in fact, one of the very first well-publicized landowners group was the group in Brooke County that I think had approximately 24,000 acres.
Wow.
The concept of a landowners group is that a bunch of people kind of form together a group and negotiate the terms of their leases as a whole. In other words, they don't negotiate on an individual basis. They try to make a market for their group and try to get different gas companies to sign a lease with their group as a whole, kind of what we call a master lease. Mm-hmm. And the theory is, and we had Jake Polachek on as a guest a long time ago, because Jake's been active in forming groups, talking about it's just you have a lot more clout when you're part of a 24,000 acre group, for example, than if you just have 20 or 30 acres. I mean, good luck, and believe me, I've tried. Good luck negotiating a lease when you only have 20 acres. You don't have a whole lot of clout with Chesapeake or Gulfport or XTO or Dominion. They kind of yawn when you tell them you've got 20 acres, but when you throw in your acreage with a bunch of other landowners and you create a very attractive group, a very attractive target, then the likelihood that you'll get better terms I think is increased. Now each case is a little bit different, but I think historically if you looked at what's happened to some of the groups around here, there was a big group that had signed a lease. There were 70,000 acres, I think, over in Ohio. And I think they were, they got $2,200, $2,300 an acre and 17.5%. Really at that time, that was about the best lease that we've seen over in Ohio. Likewise, the group in Brooke County with 24,000 acres, my understanding, and a lot of it is hearsay because I wasn't part of that group, was that they signed a very attractive lease, probably one of the best leases in West Virginia. The advantage, let's look at Brooke County. The advantage is, and I think they got approximately $5,000 an acre, 17.5%, 18%. Yeah, it was a very good lease, at least financially. There were a lot of people who weren't part of that group, a lot of our clients who called us and who were approached by landmen for Chesapeake, that was Chesapeake's deal, approached by Chesapeake after that deal was done, and Chesapeake was saying to them, to the people who were calling us, we'll give you $3,500 an acre, 15 or 16%. And they were saying, hang on a second, you just paid, we know what the group got, you just paid them $5,000 an acre, let's say 18%. They're right across the street from me, how's come I'm not getting the same terms? And the response that they were getting from the landmen was, well, if you were part